Meghan Markle and Prince Harry are allegedly shocked to learn that Prince Philip didn't leave them with a single cent. Prince Harry always thought that his late grandfather would leave him a generous sum after the latter passes away. But before Prince Philip died, he allegedly changed the contents of his last will and testament. And he decided to remove Prince Harry from the list of people that would inherit something from him. A source claimed that Prince Philip's lawyers just informed the Duke and Duchess of Sussex that they won't be getting anything, and they are both upset. But between the two, Markle was allegedly the one who was more furious. Harry can't believe that Philip didn't leave him a penny. Meghan is urging Harry to get hold of a copy of the documents, but royal aides have advised the Queen not to send the will to anyone, the source said. The source added that Prince Philip didn't also inform Queen Elizabeth regarding the changes that he made to his last will and testament. After all, he knew that the monarch would have talked him out of it. Harry was shocked, hurt, and angry. Meghan claimed there must have been some mistake. Even though he was fully aware that his grandfather wasn't on the same page as him about starting a new life in California, he assumed they were on good terms. He couldn't have been more off the mark, the source said. The Guardian was given permission by Court of Appeal Judge Lady Justice King to bring the challenge against the Attorney General and the Queen's private lawyers. The newspaper said media organisations were not told about the private hearing focused on the Duke of Edinburgh's will, which took place in July, and were consequently prevented from attending it. Following the July hearing, the President of the Family Division of the High Court, Sir Andrew McFarlane, ruled in September last year the will of late Prince Philip should remain sealed for 90 years. In its legal challenge, the newspaper intends to argue the case should be reheard in the High Court on the basis Sir Andrew failed to properly consider whether journalists should have been permitted to attend the original hearing or make representations in favour of being allowed to attend. Moreover, The Guardian claimed this move was an interference with the principle of open justice. Upon making a decision in favour of the newspaper, Lady Justice King said, "There is a real prospect of the applicant, The Guardian, succeeding on the ground that the High Court heard in law in denying the media an opportunity to make submissions, or at least to attend and hear submissions, as to whether the substantive application to seal the will of His late Royal Highness, the Prince Philip, Duke of Edinburgh should be heard in private." Buckingham Palace did not comment on this decision. The original hearing was attended only by Prince Philip's executor, Farrer & Co Trust Corporation, a subsidiary of the Queen's private solicitors Farrer & Co and Acting Attorney General Michael Ellis. Sir Andrew addressed the absence of the media at the July hearing. He previously said he accepted the argument that only the Attorney General can speak, as a matter of public law, to the public interest, and that there was, legally, therefore no role for those who might represent the media at a hearing, public or private, in putting forward any contrary view of the public interest. Upon ruling on whether the Duke of Edinburgh's will should be kept secret, Sir Andrew said in his judgment published in September, "I have held that, because of the constitutional position of the sovereign, it is appropriate to have a special practice in relation to royal wills. There is a need to enhance the protection afforded to truly private aspects of the lives of this limited group of individuals in order to maintain the dignity of the sovereign and close members of her family."